Hello, I'm Ben Wattenberg. Recently, there has been a new round of criticism of America's courts. It's said they have too much power and that they abuse it. Is that so? If so, what should be done about it? Joining us to sort through the conflict and the consensus are C. Boyden Gray, White House counsel to President Bush from 1989 to 1993, Jonathan Turley, a professor of law at George Washington University and director of their Environmental Crimes Project, Paul Rothstein, professor of law at Georgetown University, and Michael Greve, executive director of the Center for Individual Rights. The question before this House: are the courts out of order? This week on Think Tank. Throughout American history, advocates have tried to get judges to do things politicians wouldn't do or couldn't do. Traditionally, judges were reluctant to intervene in what they saw as political matters. However, in recent decades, the court has become more active. Critics say that since the Warren Court of the 1950s, the courts have grown too eager to legislate from the bench. The argument has ebbed and flowed. It's flowing again. Item: two separate federal courts, ironically for two wholly different reasons, ruled that people have a new constitutional right to assisted suicide. Item: a judge in California questioned the constitutionality and then blocked the implementation of Proposition 209, the anti-affirmative action, anti-preference statute, which had passed by a popular vote. Item: a court in Hawaii ruled that gay marriage was legal. Opponents worry about this case because the full faith and credit clause of the Constitution requires that all states honor each other's contracts and that the lone Hawaii court decision will legalize same-sex marriage in every state. Some conservatives see these sorts of rulings as over the edge and want to curb the power of the judges. Judge Robert Bork, in his best-selling book Slouching Toward Gomorrah, suggests a congressional override on Supreme Court decisions with a simple majority vote of the Congress. And last month, Tom DeLay of Texas, the third-ranking Republican in the House, actually used the I word, saying, "Articles of impeachment are being written right now." Congress has given up its responsibility in overseeing judges and their performances on the bench, and we intend to revive that and go after them in a big way. Supporters of the courts, as they are, argue that you have to take the good with the bad and that the judiciary must remain independent of the political process. Welcome, gentlemen. Let's go around the room quickly. Boyden Gray, are the courts out of order?
I don't believe so. There are occasional rulings that strike one as a bit far out, but remember, we can see a contrast now, I think, in part because of a couple of decades or a decade of Reagan-Bush judges who haven't done this, and so when you have an activist judge, it tends to stick out. I think the remedy for this is not impeachment. The remedy is not any new tinkering with the Constitution. The remedy is just a lot of vigilance in who gets appointed, who gets nominated, and who gets appointed.
Okay, Michael Greve?
I agree with a lot of that, except I do think there's a pattern where judges have handed down rulings that are very much at odds with the consensus of the voters, the consensus of the country, where they've done that without a constitutional or other legal warrant, and that it's very, very hard to do anything about it. So in that sense, I think it's fair to say that a lot of judges, if not the judiciary as a whole, is out of control.
All right, Jonathan Turley, are the courts out of order?
I don't think so. I think there's more evidence today that it's the Congress which is more showing evidence of excess than the courts. Moreover, this is a question of whose ox is being gored. I often think of judges in terms of activists who are Reagan and Bush appointees. It seems to me that there's more evidence of raw judicial activism among the Republican and conservative judges than there are with the rest of the branch. It's very hard to predict often how a Clinton judge is going to act, but I would say that
Very hard to often predict how Clinton's going to act. So that's right. And then,
That's true, but I think that there's also a little more predictability with the judges that were selected with Reagan and Bush. And that's not necessarily a good thing. And so when we talk about judicial activism, we have to remember that this is very much a two-sided coin.
Paul Rothstein.
I think you have to ask, are the people satisfied with their judiciary? And when you look at the polls of who's very respected here, you find that judges, and in particular federal judges, come out near the top, much higher than members of Congress, for example. And I think that's key to the functioning of a constitutional democracy, that the people like what the judges are doing. I've done some work abroad in the newly emerging former Soviet countries on drafting constitutions and judicial codes. They have a real problem, I think. Nobody respects the judges. They think they're under the thumb of the political system. That's not so here. Everybody knows that each person's going to be in the minority sometime on something. They like the idea that there is an impartial judiciary standing between them and the tyranny of the majority, and that it's just, for example, on the Supreme Court, 9 old men and women who have nothing to gain or lose except to satisfy their own sense of what they think is right or wrong, and that's a comforting thought to people, even though they might not like some particular decisions.
Boyden, why you swing from the conservative side of the plate? Why are the conservatives on the warpath now, if as you say, the Reagan-Bush judges that you played a large role in selecting and vetting for President Bush, if there's no problem, why?
Well, I'm not saying that there is no problem, yeah. And I certainly would like to hear examples of judicial activism among those that I contributed to selecting. But we do face now 8 years of democratically generated judges, and that may be what bothers them. I have not discussed this matter with people in the House, but the House typically has no role in the judicial selection process. It's the Senate that confirms. And as I say, the remedy is vigilance on the part of Senator Hatch and his colleagues and who they let through the screen.
What about this overruling of Proposition 209,
well,
the affirmative action thing? I mean, isn't that's sort of the classic example?
That was the Carter judge, but he got slapped down pretty quickly by the Ninth Circuit, by the appellate court. So,
not yet.
Not yet, for sure. No. But do you think he's not? You think that's not going to be?
I think eventually he will be overruled. Either in the I should disclose my organization, my law firm represents a party to that proceeding, and we of course lost in front of
you have to leave the stage now that we've
I know.
But talk about conflicts. This judge had a conflict. He should have been knocked out on the basis of sort of a bias because of his own prior association with one of the parties to the case. But I think he's going to get overruled. I mean, I think it's not going to come out the way he initially ruled.
Well, that's not such an off-the-wall decision. We may disagree with it, but it's still within the ballpark. And I think if you're going to have an independent judiciary, you have to say, as long as it's within the ballpark, a reasonable interpretation, even though it might be wrong, we might not agree with it.
I don't think it's reasonable.
It is, with all due respect, it is not in the ballpark. What it says is that a categorical rule of non-discrimination enacted by the voters of California is discriminatory. You try to explain that to any sensible person, to any ordinary person, and they say, excuse me, you really have to spend years in legal la-la land to crank up a theorist. And one of the reasons why I think the impeachment idea is not a good idea is you're really saying that we will impeach judges for a particular decision, for ruling in a particular way in a particular case. I don't hold, great respect for federal judges in all candor, but even I mean, that makes even me nervous. What you really want is you want to have a debate in the country about the larger pattern of judicial activism. And these impeachment ideas and micromanaging particular decisions and criticizing particular judges for individual decisions doesn't lead to that debate. You immediately get back to the merits of that particular case. But what Jonathan's friends really want to say is that when the judges have ruled, nobody else is allowed to do anything about it. They can do whatever they want. And that, I think, is a very dangerous idea.
In certain areas that the Constitution has marked off as areas where minority people who have a different viewpoint from the majority, are to be protected. from possible tyranny by the majority. Everybody at some point is going to be in that position of being a minority.
Yes, but some of the biggest problems arise not with a constitutional ruling, but rather with an interpretation of a statute that was never intended by Congress. I don't know how you remedy that, because Congress has the perfect right to go back in and fix it, and frequently they don't. I sometimes think that the problem is Congress doesn't do enough to rectify mistakes or exaggerations or distortions created by the judiciary. But all this gets worked out in the political system, and I again repeat that my view about this, or it's not just my view, a lot of people, that if you have complaints about the activism, the way to address it is to make sure that your selection of judges is carefully done.
But Boyden, yeah, the thing that I find somewhat ironic is that you have Senator Hatch and former leading administration officials saying that we need to have a more active role in taking out these judges. But when you were appointing judges through the administration, and when Senator Hatch was key in that effort, it was a different tune that was being sung then. Then it was, you can't oppose our judges unless there's something particularly egregious, that the Senate should look at these judges and say, you know, if we have to defer to the president's judgment, we can't micromanage every one of these jurists. And then suddenly, you know,
we lost that argument, and we were micromanaged, and now we're saying, hey, let's.
But isn't this a time to stand on principle?
But Jonathan, you know, I mean, there are people who say that the power to appoint judges is the most powerful weapon that a president has, or tool that a president has, because it goes far beyond his own term. These judges are appointed for lifetime. I mean, so shouldn't the Congress have some ability down the road to either shape the appointment or shape it later on?
Well, if I can answer quickly, I know that Boyden has something to say, but I agree with that, but there is a certain continuity that we need to preserve. There's a reason why we have life tenure. There's a reason why we defer to the president. The Reagan and Bush administration put incredibly conservative judges on the bench, and they did get through the Senate. Take a look at the judges that are being opposed by the Senate today, and I believe that the scrutiny and the standards that are being applied are far more aggressive than were applied during the Bush administration.
Let Boyden come in first, and then you, Michael.
Let me just point out
tell us about your incredibly conservative judges you appointed. Right?
There's a difference between Supreme Court, courts of appeal, and district court, and the vast bulk of the judges, of course, are district court, and in fact, they are picked, whether you like it or not, by the Senate itself, by the senators from the home state of the judge. That's the system, that's the way it works. We had something of a veto authority over the district judges, but that was all we were able. When a senator wants to get his man, his former campaign manager, in as a district court judge, unless the guy has committed adultery every day of his life, it's very hard to stop it. So I just want to make that very clear as to the district court judges. Now we could exercise some discretion, a lot, over courts of appeal, but not the district court.
We are going to run out of time unless we move from this discussion of what is wrong and what is right to what we ought to do about it, if anything. And I wanted to play a clip from a program that I did with Judge Robert Bork, which describes something that he wants to do about it. But you are proposing that we have a constitutional amendment to allow the Congress to overrule the courts with a simple majority vote.
Yeah, people get excited when you say that. But
yeah, I would think.
Yeah, but the fact is, I'm far from the first to say that. I think Robert La Follette proposed something like that, 50 years ago or so, maybe 60 or 70 years ago. Learned Hand, who was, by common consent, the greatest of our Court of Appeals judges, wanted to take provisions out of the Constitution to keep the courts from doing what they were doing. He was quite upset with the courts, and he had a point. He said, either you have to get judges who have self-restraint, or you have to have some means of democratic control. We have failed to get judges with self-restraint. Therefore, I think the next step is to try to get democratic control.
Judge Bork says that's nothing to get excited about. Is that something to get excited about?
Yes.
Yes.
Something to get very excited about. Do you want Congress making these decisions rather than the judiciary, people who have nothing to gain or lose except to satisfy their own sense of what is right. Who's more respected, Congress or the courts? I rest my case.
Well, I also think that Judge Bork has done the one thing that will bring learned hand back from the grave. What Judge Bork is referring to with learned hand is learned hand's opposition, I believe, to the age of expanding contractual rights in that area of law. He was not giving the sort of overarching principle that Judge Bork attributes to him. But the biggest problem, I think, with Judge Bork's position is that the problems that he envisions as to the politicalization of the judiciary are nothing in comparison that would come from his type of amendment. Congress most certainly would use that power, but you don't have to look very far back in history to see where that would take us. We created a nation to try to get away from that type of system, and it's surprising that Judge Bork seems to be...
We created a nation to get away from a monarchy, as I recall.
Well, we
not
created a
from
system in
legislative,
part to get away from things like bills of attainder and legislative decisions for individuals and cases.
Congress can do what Bork says in most of the areas. It can, if there's a statutory interpretation, Congress can change it. The only thing Congress can't change is the few constitutional decisions that are in the Constitution to protect minorities from the majority will.
Those are not a few decisions. Look, I don't think I don't think it's something to get really excited about. I mean, Canada has something very much like what Judge Bork is proposing. It's not a fascist country, lest anyone look.
Would you favor
Democracy.
that? Now, let's
no,
just
I wouldn't
repeat.
favor it.
You're against that.
yeah.
Boyden, are you against that?
I'm against that, yes, and I don't think that really solves the problem. As I said earlier, and others have said, many of the cases, if not most, are statutory interpretation, which the Congress could have overruled in the interim for the last 30 years and didn't do it, or 25 years. I would say, again, repeat, vigilance in who you select. I would say, for example, that the American Bar Association, which is a very liberal group with an agenda, a programmatic agenda, they should not be passing judgment on these nominees the way they do.
And the judges you selected are the most hostile statutory interpreters when it comes to environmental laws and other laws that they have a philosophical difficulty with. I mean, you must certainly accept that the statutory interpretation of the judges that you helped select is vastly different and pretty hostile to those areas.
And properly so, and properly so.
But those judges, on the other hand, take expansive readings when it comes to criminal cases, side almost uniformly with the government. And it's that predictability, putting aside the philosophy, it's the crushing predictability of the Bush and Reagan judges, which is so problematic. You know, when you go into court and see a Clinton administration judge, you're often completely uncertain how that person will come out. You see a Reagan and Bush judge, and you can predict.
I think predictability is very positive for the rule of law. That is what, at rock bottom, an independent judiciary is all about. The litigants with commercial disputes have some sense that they're going to be treated in a consistent fashion.
But Boyden, some of our greatest
you're paying
judges,
high praise to
so
those
some
of
our
us
greatest,
that work.
take a look at Learned Hand. Some of our greatest judges are the judges that broke from the pack. If Learned Hand had gone before the committee under your administration, he would have lasted a nanosecond. He had committed the sin of all sins. He had actually written something before his appointment. And we're slowly squeezing
Hey, wait, hang on. It was the liberal side that got into this business of attacking people, namely Judge Bork, who we just heard from, because he had a paper trail.
And I must say,
and an extensive one, which you could pick little pieces out. Now you can't say.
Which is why we have Souter, because he was somebody who had no paper trail.
And I must say
right.
that Judge Bork seems to be rushing to prove the validity of that decision. He himself says that he would dissent in every case, that his views are considered extremist, which was precisely what the complaints were. But I'm surprised that I can't agree with Boyden right now, since Boyden said he lost that battle of saying that we should defer to the president. This is a time to stand on principle for the Republicans to set the record and say that we have to adopt some parameters within which the president is allowed to act. The president was selected by the entire nation. His appointments on the bench reflect his interest, as did his election. And instead of standing on principle, we have the Republicans saying, well, we were abused and now we're going to abuse you too.
I think it's appropriate for the Republicans for this to be a bipartisan approach to selecting judges, and for the Republicans to carefully screen the president's nominees.
All the people collectively also elected the Senate,
Yes.
which is charged by the Constitution.
Not the nation, only individual states
I say
elected
collectively.
each of these
Collectively,
senators.
they
Right.
elected over a period of years a majority Republican Senate, which is charged constitutionally to vet those nominees.
I agree.
So why shouldn't they say, well, the president may or may not be putting an ideological test on these things. I mean, he comes from a certain viewpoint. We come from a certain viewpoint. Let's cut the cards and see what the political system that the people have elected to do.
So then there won't be impeachment drives later to impeach, because they've all had their say at the beginning.
But Paul-
I think
Right,
that's
and that's
sound.
the way it ought to be.
It seems to me that you want to, as I said before, you want to get away from the issue of particular individual decisions in individual cases. What you're really concerned about is a pattern. What most states now have is periodic reappointments. The judges aren't up there, justices in Supreme Courts aren't up there for life. They're up there for a period of years and then subject to reappointment. The process differs
I think
from,
that's a bad
from
idea.
state
No, I
to
think
state.
it's- I think that's
Wait
a
a minute,
terrible
wait a
idea.
minute.
Yeah.
That way, I mean, there is some recourse, and you don't have to throw them off the bench as Judge Silverman.
Of course you won't,
said.
because you
No!
have this lingering threat that within 10 years they're going to go back into the shark pool.
No,
of
they're
course
not.
you don't.
They
No,
have
wait
to
a minute,
please
wait
the
a minute,
bosses
wait
to
a
get
minute, wait a
reelected.
minute. The only, if that is what you're concerned about, the only court we're really concerned about is the Supreme Court, and as Judge Silverman has suggested, you can just rotate them off and back to an appellate bench after a while. That way they don't have to go into the shark tank. In all candor, I mean, what would happen is judges wouldn't get sort of reprimanded for individual decisions. People would say, okay, Justice Kennedy wrote that one opinion in Evans versus Roma, the homosexual rights case, but by and large, he's been okay. What they would say, however, is, look, are there judges or justices who have consistently behaved with great disrespect for the democratic process and their constitutional oath? And in that case, yes, we want to not get them and gotcha, but we probably come to the conclusion that they don't belong on the
Michael,
bench,
the
just
one
as the
court-
voters of
That
California.
turns
Let
into a witch hunt, a political witch hunt.
Let
Now
us talk constructively. We have just one new idea on the table, which is the periodic reappointment. Any other ideas to not destroy the system but constructively reform it?
I hope that since we have 2 votes, at least Boyden will join me in saying I think it's a perfectly rotten idea to change the makeup of the Supreme Court. The Supreme Court's been a key
But what
institution.
are you for?
I'm actually, see, the problem here is that I am not convinced at all that we have any pattern at all. It seems that we're very, very quick in this country to question institutions, to remake great institutions in small images. There's nothing wrong with the way the Supreme Court has acted. Listen,
Except that you think they're a bunch of right-wing zealots now.
but you're talking to somebody who's been on the wrong side of this Supreme Court. It's my ox that's being gored right now, and I still think that people like Rehnquist and Thomas and Scalia should be guaranteed life appointment, even that it sticks in my throat, because it's vital that they be guaranteed that. Because if you look in history, the Supreme Court has stood at critical points in history, stood up to the White House, stood up to the public, and made those decisions. And this type of rotation idea is to fix a problem that simply doesn't exist.
Jonathan, are you suggesting that Bork is trying to destroy the court for sour grapes because he didn't get on? I thought I saw that implication in something you were saying.
No, I think that if anything, Robert Bork is certainly proving the validity of your idea that there should be close scrutiny of a political type in the Senate. With all due respect to Judge Bork, his recent extremist decisions would validate his
weren't
opponents.
decisions.
I'm sorry.
He is now a member of the pundit class, and
Yes, the
we
pundit
have a charter.
We have First Amendment rights to say anything.
We have a charter even broader than lawyers.
Yeah,
We can say anything we want.
Well, let me just change the subject slightly. That I'm a regulatory lawyer. That's part of what you teach. The court that has much more to say about the regulatory burden of the United States, which has much more to do with productivity and wages and how we live in many ways than what the Supreme Court does, is the Court of Appeals. And there, it is very critical to be very careful who you put. Very, very important.
And don't you think they're doing a pretty good job?
They're doing a pretty good job
In all those areas.
In all those
They're
areas.
still his appointees.
Do you believe there
They're
should be
still
a
our
rotation
appointees.
on the Supreme Court?
No.
Okay, on that note, we thank you, Boyden Gray, Paul Rothstein, Michael Greve, and Jonathan Turley. And thank you.
We at Think Tank depend on your views to make our show better. Please send your questions and comments to New River Media, 1150 17th Street Northwest, Washington, D.C. 20036, or email us at thinktank@pbs.org. To learn more about Think Tank, visit PBS online at www.pbs.org. And please let us know where you watch Think Tank.
For Think Tank, I'm Ben Wattenberg.
This has been a production of BJW Incorporated in association with New River Media, which are solely responsible for its content.